Up to now, we have studied what is known as equity and what is known as common law and fusion of the administration of law and equity or the fusion of law and equity. Today in this lecture, we are going to see the nature of the equitable rights. There has been unsettled controversy on the question of the nature of the equitable rights and particularly of the nature of the interest of the beneficiary under a trust. In its simplest form, one view emphasizes the fact that a beneficiary's remedy historically and practically is in the form of an action against the trustee. That is a right in persona. On the other hand, equitable interests under the trust are equitable proprietary interests corresponding to the legal estates, and the beneficiary can be regarded as the owner of the beneficial interest. Beneficiary is the ownership is a right in rem. Much of this controversy centered upon whether the beneficiary's right was in right in personam or right in rem. The proper meaning of a right in rem in the present context is a right enforceable against the world with respect to a particular thing, that is the property. It is assumed throughout that a legal owner does have the right in rem. Now when you see here in the PowerPoint presentation, one view emphasizes the fact that beneficiary's remedy is in the form of action against the trustee. That is known as right in persona. On the other hand, as we have seen now, the equitable interest under the trust are equitable proprietary interests corresponding to the legal estate, that's a legal trust property. And beneficiary can properly be regarded as the owner of the beneficial interest, and ownership is the right in rem. Now in this context, what we are seeing here, if you have the ownership, then you have the right in rem. If you have some sort of interest, then you have the right in persona. Then move to the other PowerPoint, the other slide here. The right against all the world with respect to particular thing, that's the right in rem. Rem in the sense that the property. Then rights against all the world, all the person in the world in respect of a property. The basis of equitable jurisdiction historically and presently is that in accordance with the maxim, equity acts in persona. Equitable rights grew up where the chancellor was willing to intervene. Equity did not say that beneficiary was the owner of the land. It said that trustee was the owner of the land, but added that he was bound to hold the property for the benefit of beneficiary. Now in this one, the Roman law, the rem and personam is are the Latin terms. In Roman law, from which they are taken, the expression in rem and in personam were always opposed to one another. An act of proceeding in personam being one done or directed against or with reference to the specific person. That's right in personam, against the person. While an act or the proceeding in rem, that is particular thing, that's a property, was one done or directed with reference to no specific person, that's in relation to the property, consequently against or with reference to all whom it might concern or all the world. A simple example that we can see now. If you have a land, one trespasser enters into the land. If you stop him, the first question he will ask you, who are you? Then you are the owner of the property. You are the owner of the property. Then you have the right to stop him because the property vested to you. Then ownership. If you have the ownership, then you have right in rem. The phrases were specially applied to an actions. An actio in personam being the remedy where a claim against specific person arose out of an obligation. While actio in rem was one brought for the assertion of a right of a property and so many etc. against one who denied or infringed it. Now the example that we have seen here, the trespasser enters into the land, then if you have the ownership only you can stop it. You can challenge it, you can punish him, you can take action against him. For that you must have the ownership. Then if you bring an action with the ownership, that is known as action in right in rem. Now we will move to other one. The proper meaning of right in rem is a right enforceable against the world. What's the meaning of against the world? Now we don't know who is going to enter or trespass into the land. We don't know. Then the right is given to us against anybody who enters into the land. That's why here we say that the proper meaning of the right in rem is a right enforceable against the world with respect of to a particular thing, that's a property or trust property. Legal owner does not have the right in rem. The right against the world with respect of particular thing. Legal owner does, sorry, I made mistake. The legal owner does have the right in rem, and right, that is the right against the world in the sense anybody, whoever it is, trespasses into the land, then the ownership. If you have the ownership, you have the right in rem. That is the action you can take against him. In accordance with the maxim, equity acts in person. Equity did not say that Selvakku trust was the owner of the land. Selvakku trust in the sense that's the beneficiary. That's a Latin terms again. Selvakku trust. Then in accordance with the maxim, the equity acts in persona. Equity did not say that Selvakku trust was the owner of the land. Then who is the owner? It said that trustee is the owner of the land. Because as we have seen several times, if the author of the trust transferred the property to the trustee, then once the transfer is over, then trustee is the owner of the property. Trustee is the legal owner of the property. That's why here we say that in accordance with the maxim, equity acts in persona. Equity did not say Selvakku trust was the owner of the land. It said trustee is the owner of the land. perfect, but was bound. The trustee was bound to hold the property for the benefit of Setiki Trust. The maxim that equity acts in personam does not prevent us from treating the beneficiary under a trust as having an equitable ownership. Equitable ownership and ownership in law, legal ownership. We will come back to that one later after we finish this one. A beneficiary's interest behind a trust has long been treated as having a basic characteristics of a proprietary interest in that it can be sold or mortgaged. Historically, the protection of beneficiary was based on the chancellor's willingness to proceed in personam against trustee. That protection has ended up by creating the rights in the nature of the ownership. Now when you see the first one, the maxim that equity acts in personam does not prevent us from treating the beneficiary under a trust as having equitable ownership. Now the issue here, property, as we have taken the example, the owner of the trust transferred his property to the trustee. Once the transaction is over, B is the legal owner of the property. Then he holds the property for the benefit of C, who is the beneficiary. Then the trustee holds the property for the benefit of beneficiary. Then beneficial interest, that is there. The beneficial interest should go to the beneficiary. Then the trust is there. Then the property is transferred to trustee and property transferred to trustee, and trustee is the legal owner. There is no doubt at all. Trustee must hold the property for the benefit of beneficiary, in the sense the beneficial interest should be given to the beneficiary. Should be given to the beneficiary. Then the beneficial, when you talk about the beneficial interest, who is the owner of the beneficial interest? The beneficiary is the owner of the beneficial interest. That's why in certain cases, in certain circumstances, it was argued that beneficiary also has some sort of ownership of these beneficial interests. The beneficiary's interest behind a trust has long been treated as having basic characteristic of proprietary interest. That's the thing. The beneficial interest is there. Beneficial interest. Who is the owner of the beneficial interest? Beneficiary. The beneficial interest can be sold, can be mortgaged. Historically, protection of the beneficiary was based, that we have seen, proceed to in personam against the trustee. The protection has ended up by creating a right in the nature of ownership. Now the property, say the author of the trust transferred the property to trustee. Now the trustee is the legal owner. In terms of the trust deed, end of the trust, that should be transferred to beneficiary. In that case, beneficiary becomes owner of the land. Then the all trust obligations come to the end. This raised a question of the effect of the sale of a land by trustee. The answer was that the beneficiary's interest was effective against everyone except a bona fide purchaser for valuable consideration without notice of equitable interest. Now, suppose there is a trust property without any knowledge that the property is subject to trust. The third person purchased the property, then that third person known as a bona fide purchaser. He purchased for valuable consideration. Then we don't know what happened. That person, he doesn't know about the trust. Then in that case, what's the situation here? The trustee is the owner at law, the beneficiary is the owner in equity. Trustee is the owner at law because the property transferred to him, but the beneficiary is owner of the property in equity. Trustee files an action or sues for the possession of the trust property. Trustee, not the beneficiary, sues for the conversion of trust property. Then now the thing is, if anybody transfer the property, or suppose even anything happened to the property, then the trustee must take an action. Then if the next line is like that, the beneficiary is right to compel the trustee to take action. The certain cases, beneficiary take action himself on behalf of the trust, joining with the trustee as defendant. Now suppose the trust property is there. The trespasser enters into the trust property. But really speaking, trustee is the legal owner, then the trustee must take action against the trespasser. But he doesn't do anything, just ignore that's a trust property, why should I take action? In that case, beneficiary has a right to take action against the trustee and compel him to take action against the trespasser. There are circumstances where even beneficiary may take action against the trespasser, joining with the trustee as defendant. The trustee has sold the property to bona fide purchaser. That's the issue here. Bona fide purchaser. Here trustee would defeat the equitable ownership of the beneficiary because the purchaser is a bona fide purchaser, then the beneficiary can't take any interest on that. That we will see a little later now. In this situation, bona fide purchaser is not determinative of question whether the beneficiary's interest is proprietary or whether his rights are in rem or persona. It demonstrates simply that legal and equitable ownership may have different effect. In practical point of view, it can be said. In the practical point of view, it can be said that where the problem involves the working of the trust machinery so that beneficiary asserts his right by action against the trustee, enforce the trustee's duty. The old theory that equity acts in personam is wholly acceptable. But in other cases, the theoretical view is overtaken by pragmatic approach, so it depends on the language of the statute. Now in this case, now right in rem and right in personam. Right in personam in the sense, now here there is no space here to run through every aspect of equity jurisdiction to establish the point that equity acts in personam. One practical application of this proposition is the fact that the court of equity will exercise to order a specific performance to the administrator assets abroad if the executor are in England. Now the assets outside England, but the executor is in England, then the order can be given to the executor if the action is in right in personam. If the action is in right in personam, then the order can be granted. If it is rem, then you must file a case in the country where the property situated. Now, trustee is the owner at law and the beneficiary is the owner at equity that we have seen. The reason analyzed that the interest of the beneficiary is negative or exclusionary. It is a negative in the sense, negative rights to exclude non-beneficiary from the assets, as opposed to the positive right to impose the duties on them, impose the trustees' duty on them. Now, this is another way in which they explain. Now, we said that only owner, or if you have the ownership only, you can go for right in rem. If you don't have, then you can go for right in personam. This is something another where beneficiary take action against the person to exclude non-beneficiary from the assets. And also this is something opposed to the positive right, you impose the trustee duty on them. Once again, that another case also, another view is given here. Beneficiary's interest is bundle of the personam, equitable rights against the trustee, because always equity acts in personam. Therefore, beneficiary's interest, beneficiary has no legal title of the trust property. Therefore, if anything in relation to the trust property, then the beneficiary must file an action against the trustee and compel him to do certain things. The trustee sues for conversion of property that we have already seen. Then in this case also, once again, it has been held the duty of care may be owed to the beneficial owner of the property just as much as to the legal owner. This is something very criticized, this judgment criticized, because as blurring the legal and equitable ownership in the manner contrary to the principles and authority decided for a long time. The equity did not say Setiki Trust was the owner of the land. It said that trustee was the owner of the land and added that he has some sort of duty to hold the property for the benefit of beneficiary that we have seen. A beneficiary interest behind a trust has been treated as having basic characteristics of a proprietary interest in that it can be brought or sold or mortgaged or devised or whatever that can be, because that's the beneficial interest. Beneficial interest is something. Who is the owner of the beneficial interest? Beneficiary. Beneficiary is the owner of the beneficial interest. From that, this concept is derived. Even the protection of the beneficiary was based on chancellor willing to proceed with the person against the trustee. The protection has ended up that we have seen already. And to argue the beneficiary is not to say that the legal rights are same as equitable or equitable ownership same as. The basic issue is here, legal ownership, equitable ownership. Legal rights, equitable rights. are not same, totally different thing. Once a property transferred to trustee, trustee is the legal owner. If you see the common law, trustee is the full owner of the property. He has the full power to dispose the property. But the equity says, that's fine, you are the legal owner, but there is a duty. There is a duty, you are bound to give some sort of beneficial interest to beneficiary. That's why you must hold the property for the benefit of beneficiary. Rather, it is to accept the basic peculiarity of the ownership under English law of trust. Trustee is the loan owner at law, beneficiary is the owner in equity. Trust is used for rent and possession and everything, because trustee is the owner of the property. If the property is rent out, then who must collect the rent? The trustee must collect the rent. And the personality. The trustee, not the beneficiary, is for conversion of the property that we are saying. Beneficiary is right to compel the trustee to take action. He may some cases take action that we have seen, joining with the trustee as defender. The right sometimes may be inadequate as where the trustee has sold the property to the bona fide purchaser of a legal estate for a value without notice, who will defeat the equitable ownership of the beneficiary. Now the example here, beneficiary sold the trust property to another third party. The third party purchased the property without knowing that the property was subject to the trust. Then in that case, the third party will defeat the equitable ownership of the beneficiary. Now we have a clear section in the trust ordinance. Section 65 of the trust ordinance in Sri Lanka, where the trust property comes into the hands of third person inconsistently with the trust, the beneficiary may institute a suit for declaration that the property comprised in the trust. Now the one case here, the property inconsistently transferred to third person. Then you can go and ask that property is subject to trust. Then even the property transferred to third person must hold the property for the benefit of this beneficiary. That's one thing. Where the trustee has disposed of the trust property, and the money or the other property which he has received therefore can be traced in his hands or the hands of the legal representative, then the beneficiary has, in respect thereof, the rights as nearly as may be the same rights in respect of original trust property. Now, if the third person purchases a property without knowledge that the property was subject to trust, then whatever the trustee got that consideration, suppose money or whatever, then again the beneficiary file an action asked to declare that whatever money or consideration that the trustee received subject to trust. That's the section 65 that we will study later. Later when we study this trust law, we will see the sections. Now we will move to next one. Now here the France. The case is in England, but the case is in France also. Where a father bought a flat in France, then the right in France, in his son's name, sought a declaration that son was the trustee. Father purchased a property in France, and the name executed in son's name. Now he seeks for a declaration that son is the trustee. And the order to vest the property in father. The action was classified as in personam for the purpose of convention. Then the son's claim, only the French court had the jurisdiction, failed, because this is a right in personam. Right in personam in the sense, if the person within the jurisdiction, then the English court has the power to direct, not the French court. Then the other example also we can see here, where a wife sought a declaration in the English court as to her beneficial interest in the land in England. Her claim classified as in personam again. Then the English court did not have the exclusive jurisdiction. The action was stayed because her husband already commenced the divorce case and other reliefs proceedings in France. Then stopped. Then further we can see here, on the other hand, here this Hayward case, the claims by a trustee in bankruptcy of a deceased legal and beneficial co-owner of villa in Spain to his share of the property was held to be right in rem. So that Spanish court, because you can't file a case in English court because it is a right in rem, then you must file a case in the Spanish court because Spanish court has the exclusive jurisdiction under the convention. Now we have seen now very clearly what is the nature of the equitable rights. Now we will see what's a common law and remedies and equitable remedies. As at the common law, the usual remedy is the award of damages, and that is available as of right. Now the damages under common law, for each and every problem, each and every issues, the usual remedy is available, that is award of damages. That is available as of right. As a right, you can claim the damages from court, or you can claim the damages from other party in the court. One of the most significant contributions of equity is the wide range of remedies. Now in the common law you can ask for damages, but in the equity you have range of remedies. These remedies are discretionary, that's the issue. Now the equitable remedies are discretionary remedies, but the damages like a right. You have the right for the damages, but equitable remedies are discretionary, and their availability in any given case may be hinged upon the application of the maxims of equity. They are granted in circumstances where common law damages are inadequate. Now the interesting part here, if you go for a damages in the common law courts, under common law, that's a right. You can ask for it as a right. But if you go for equitable remedies, that's not the right. That's a discretionary jurisdiction or discretionary issues. Then you can ask as a right, that's a discretion of the court whether to give some sort of equitable remedies to that person. They are granted in the circumstances where the common law damages are inadequate. That's very important. If the damages are inadequate, then only we can go for equitable remedies. And are in personam, that is, they are targeted at the defendant personally. Major types of equitable remedies are specific performance that you have studied in your law of contract, and injunctions, rectification, and rescission. Now here, main result of the distinction between common law and equity is that each has distinct claim and remedies. When you see the common law is a system which is able to award cash damages follows. That's the damages, all damages for loss. Common law claims such as breach of contract, negligence, and fraud, and remedies such as damages or tracing a property. Equitable claims such as breach of trust, claiming a property, and equitable remedies such as specific performance, injunction, rescission, and rectification. When you talk about this one, the main equitable remedies that we must learn or we must study now, that's specific performance, injunction, rescission, and rectification. Specific performance. When you see the specific performance, the remedy of specific performance is an order of the court which directs the defendant to perform his side of a contract. There's an obligation, the court order the defendant or direct the defendant to perform his side of the contract or his obligation. The specific performance operates in relation to the entire contract and not merely a part of the agreement. The claimant has to come with the clean hands. That's very important. Clean hands. You should not do or you should not commit any other violation there. That's why claimant has to come with the clean hands and to apply for the relief without unreasonable delay. If you ask for specific performance, first of all, you must keep it in your mind that is a discretionary remedies. Not as a right, you can't ask for specific performance. If the court satisfies, only that may be granted. Otherwise, you are not entitled for specific performance. But whereas the damages under common law relief, as a common law relief, you have a right to claim that. Now, when you apply for the specific performance, you must come to the court with the clean hands, and also you must apply for the relief without unreasonable delay. When granted, there will be either as to alternative to or in addition to the damages for the breach of contract. Now, the damages may be granted once the damages are not sufficient, then the specific performance may be granted. Sometimes no damages but specific performance only granted, ordered. That's why here we say that when granted, this will be either as an alternative to or in addition to the damage for the breach of contract. The remedy will not granted, the damages would adequately compensate the claimant. Now the damages are enough to compensate, then no specific performance order will be granted. An action for a specific performance may be commenced even before there has been an actual breach of contract. This would arise where there is an anticipatory breach. Now you no need to wait until the person violate or breach the obligation. There's an anticipatory breach. Then you can file an action. For example, when one party has stated that his intention not to perform his side of the contract, then specific performance may be asked and it can be given. Then the specific performance is not available for all types of contract. There are sometimes the person can be compensated by way of damage, paying the damages. In that case, you can talk about specific performance. But there are circumstances where you can get only, you can compensate those things by way of specific performance. In that case, the specific performance should be granted. Now here, what we have seen here, the specific performance is an equitable remedy. When you say equitable remedy, you must know that that is the discretion of the court. Not as a right. You can't ask specific performance as a right. That is an equitable remedy in relation to the enforcement of contract. An award of specific performance compels the defendant to perform the contractual obligation that we have seen. And again, it is a discretionary remedy. Now there are cases given here that we can see the cases now. Yes, here specific performance traditionally regarded in English law as an exceptional remedy as opposed to the common law remedy of damages, to which plaintiff is entitled as right, that we have seen. Specific performance was part of the discretionary jurisdiction of the Court of Chancery to do justice in cases in which the remedies available at common law were inadequate. The clear idea is, if the damages are enough to compensate, then no specific performance at all. And also, this is discretionary jurisdiction, discretionary relief. If the court satisfies, then it may order. Otherwise, no specific performance. Specific performance is an order which is made to require the performance of contractual obligation in certain circumstances. Order requires only the performance obligation, does not rest on there having been some breach of contract that we have seen now. Contracts where the specific performance available. Underlying the principles in relation to the real property is that each parcel of the land is unique, so that award of damages would be insufficient compensation for a failure to transfer a specified piece of land. There's a land. From generation by generation, it should come to within the family. Then by paying compensation, that cannot be, paying compensation, you can't satisfy them, because the parcel of the land is very unique. Then you must get such land. That is the only way to satisfy your reasonable relief. That's why certain cases where the damages would be insufficient, in those cases specific performance is available. Therefore, buyer of the land may be able to impose an award of specific performance on the seller to compel the transfer. The underlying in relation to the contracts for the transfer of chattels, that's a goods, is that specific performance will be ordered in circumstances in which the good has a intrinsic value, that's the unique value, that's a specific value, special value, such that it would not be readily possible to acquire the substitute good. Settled in the sense good. Right. Now the contract where the specific performance is unavailable. The remedy is displaced in a situation in which performance is impracticable. That's the next paragraph specifies those things. Contracts involving the personal skills of one of the parties are clearest example of contracts which will not be specifically enforced on the basis that an order of specific performance would be inappropriate in the circumstances. Suppose now you can't compel anybody or any expert or the suppose the doctor to do surgery, because then you can go for damages. Not you can't. There's a special the personal skill of a person of a party. Then you can ask for a specific performance. In this case, A entered into the contract to sell his land to B. The completion of sale was delayed because of certain personal difficulties on the part of A. At the time he agreed to sell, he was wealthy and healthy. But however, during the delay, he contracted cancer and hospitalized. He became heavily reliant on friends and neighbors. We sought a specific performance of a contract, but that's unreasonable. But anyway, it was held that exceptionally specific performance may be refused because of change of situation or circumstances subsequent to the contracts, such that degree of specific performance would inflict on the defendant a hardship amounting to injustice. He has done the contract. He entered into the contract to sell the property. At the time, he was all right and he was healthy and wealthy person. Now he was totally out, hospitalized. He is dependent to somebody. In that case, you can't ask for a specific performance because it may be amounting to injustice. Now we will see injunction. What is injunction? That's here. An injunction is an order of the court which requires a person either to do something, sometimes it is known as positive or mandatory injunction, or refrain from doing something, negative or prohibitory injunction. Any person who suffers from an infringement of an equitable or legal right may apply for injunctive relief. The damages may be ordered in lieu of or in addition to the injunction. That's very interesting. Again, I would like to emphasize here, injunction also equitable remedy, that also discretionary jurisdiction. You can ask injunction as a right. That's a discretionary right. If the court satisfied, may give or may not. The injunctions, there are so many types of injunction that we'll see now here. The prohibitory injunction is an injunction which forbids the parties to do or to continue to do unlawful acts. Mandatory injunction is an order that an act be undone. Hence, the mandatory injunction which granted is likely to undo a wrongful act rather than to order defendant to carry out a positive obligation. This type of injunction is uncommon. Then the perpetual or final injunction is an order made in final settlement of the dispute between the parties and issued at the completion of the court proceedings. Interim injunction, that's in the civil procedure, you will study in your final year subject. Here we will introduce that interim injunction. Interim injunction is an injunction made during the course of legal proceedings and which is effective only until the trial of the action takes place. It is designed to restrain the defendant immediately while waiting for a full court hearing. Then ex parte injunction, that's a final one, we must see that. There is an injunction granted in an emergency without other side having been informed or given an opportunity to attend the hearing of the application. These are the main injunctions available under trust, as well as you can see in the civil procedure also. Then the injunction is equitable remedy. That's a discretionary remedy that we have seen. It is a discretion of the court to make an order either to party litigation. Discretion of the court to make an order to either party to litigation. An injunction will be awarded on an interim or permanent basis, in a mandatory or prohibitory form that we have seen and explained to you. It is necessary that no common law remedy would be sufficient in circumstances. The applicant must come with a clean hands. There must not have been delay in the applicant part. Some rights of the applicant must be affected. Respondent must not suffer undue harm as a result of injunction. That also we must, then only it must be a justice. Injunction divided between those which request some action from respondent that we have seen, those which require the respondent refrain from some action that we have seen now, and those which seek to prevent some action which is feared may be performed in future. Interim injunction also we have seen. The interim injunction is awarded on interim basis during the litigation that we have seen. The award is based on the balance of convenience between the potential harm suffered to the applicant if no injunction were awarded, and the potential convenience caused to the respondent if injunction were to be awarded. Then we must see the balance of convenience and issue the injunction. Because if there may be a construction work going on, then you stop the construction work, there may be damages. There may be sufferings to the respondent. Then we must see the balance of convenience to decide whether to award injunction. An injunction will not be ordered in the circumstances where the damage is sufficient. That we have seen from the beginning. If the common law remedy is the damage, first place the court will see whether the damage is sufficient. If the damage is sufficient, then you can ask for specific performance or whatever. Now we will move to next one, that is rescission. The rescission is a remedy employed to set aside the contract and restore the parties to their pre-contractual position. The contract is voidable and remains until rescinded, perfectly valid. Accordingly, The rescission reflects the desire of the party no longer to bound by the contract. This is also, as I told you again and again, equitable remedy as well as discretionary remedy. The rescission is the equitable remedy used to set aside the contract that we have seen. Then these are the cases of fraudulent misrepresentation. The claimant will be entitled to rescind the contract to prevent the wrongdoer from benefiting from its wrongdoing. Material mistake made by both parties to the contract will enable that contract to be rescinded. The right to rescind will be lost where it is impossible to return the parties to the position they occupied previously, where the contract has been affirmed and where there has been delay. Right, then finally we will see the rectification. Rectification is another equitable remedy here. The remedy of rectification concerns the rewriting of documents to accord with what the parties agreed in bilateral transactions. The remedy is designed to rectify mistakes made. It is crucial that it was intended that the term appear in the written agreement. If it was deliberately omitted and the mistake is as to a legal consequence of the document, rectification is not available. Deliberately omitted, then no rectification. The mistake is as to the legal consequence of the document. Now you agreed the document, but legal consequence is something different, but rectification is not available. Purpose of the rectification is to correct mistakes in the way the translation has been recorded. It does not allow the parties to change the substance of the agreement reached. Although it is a discretionary remedy, rectification will be awarded unless damages are a suitable alternative. The rectification available to amend the terms and contract better to reflect the true intention of the parties. If the intention is something different from what they have put it in the document, then they can for rectification. Then the rectification will be available in circumstance of common mistakes. That is the end of nature of equitable remedies and equitable claims and equitable remedies. That is the end of these lectures. Thank you for watching.